Good evening, everyone. I'm Valerie Couch, and I'm the chair of the Oklahoma City Human Rights Commission, and I want to welcome everyone. I'm going to take the personal privilege of coming down here to call the meeting to order and get started. I wanted to welcome everyone, but I want to begin by especially welcoming our new commissioner, Stephanie Holloway, this is her first meeting as a commissioner with us, and she is from Ward 5, and later on in the agenda I'm going to introduce her more fully, but I just wanted to start by saying how happy we are to have her on the commission. This is an open meeting. All of our meetings are open meetings, and we follow the published agenda that's posted before our meeting. A recording is made of the meeting and is posted on our website, so you can go back and watch this exciting Human Rights Commission meeting if you'd like. It's always available to the public. This evening, our meeting is going to begin with an educational program that's going to last about 1 hour. And this is going to be focused on public accommodations and the Americans with Disabilities Act. After that presentation, that educational program, we'll take a 5-minute break, and then we'll resume in this room to address the remaining items on the agenda. If you would like to address the Human Rights Commission, we have a time in the agenda for you to do that. It is important, though, for you to sign up to speak directly to the commission, and you do that by touching base with Tammy Maxwell, who will give you a blue sheet to sign up with. So please do that. We already have a couple of people signed up to speak, and we look forward to hearing from you. All right, I'm going to ask the commissioners to come down into the audience so that we can participate as among all of you in learning about the Americans with Disabilities Act. As they come down into the audience, I'm going to briefly introduce our 3 speakers for tonight. We have 2 attorneys who are with us tonight, Joy Turner and Brian Wilkerson, right over here, and they are attorneys with the Oklahoma Disability Law Center. The Oklahoma Disability Law Center is a federally funded operation called a protection and advocacy system, and they do tremendous work for people with disabilities in Oklahoma. Between the 2 of them, they've been representing people with disabilities for many, many years. They're very knowledgeable experts in this area, and it's a very complicated area. So we're really happy to have them with us tonight so that we can learn more about the complexities of this area. We also have Scott Hodgson here with us, and his presentation will come after Joy Turner's and Brian Wilkerson's. He is the new ADA coordinator for the city of Oklahoma City. So we will hear from him about his work, his responsibilities, and also the efforts and projects that the city has going in this area. So I'm excited to hear from everyone. At the end of both of the presentations, if we have time, we'll have a Q&A session on the subject matters of their presentations. So with that, let's welcome Joy and Brian, and we'll make sure these microphones work. I'm going to hand over this microphone for you to use if you need. Okay? Okay. Thank you. Is that on?
I think she left it on.
Okay.
I don't know that I'll need it.
Okay.
Good evening, everyone. We want to thank everyone that came out to the meeting tonight. We especially want to thank the commissioners and the commission for asking us to be here. My name is Brian Wilkerson. I'm an attorney with the Oklahoma Disability Law Center. I am the legal director at the center, and I've been with them for 7 years as of this month. And this is my counterpart, Joy Turner.
Hi, I'm the Director of Investigation and Monitoring, and I've been with the center for almost 25 years.
And just a little bit of personal information about myself. I'm married. I have 2 adult children, both of whom have disabilities. One of whom lives with us full-time and probably will for the rest of his life. So not only is this part of what I do in my everyday career, but it's also part of my everyday life and has been for a long time now. My son's 26 now, and great young man, and I'm very proud of him. But it reminds you every day, it reminds me every day at least, why we do the work that we do. So with that, I don't know if you want to.
All right, we'll just get started then. All right. Are you fine with me doing it, or do you want to? It works. Yeah. Okay. All right. So the Americans with Disabilities Act. Who does it apply to? We'll start there with the very basics. This is really going to be a broad kind of broad coverage of the ADA, and then we're not going to hit the nitty-gritties because there's a lot to the nitty-gritties, but if you do have questions, save those till later and we can hopefully answer those. So it applies to, Title I applies to employers, both the public sector and the private sector. Title II applies to state and local governments, often called public entities. Title III applies to places of public accommodation. Title IV applies to telecommunications, and Title V is the miscellaneous provision of the Americans with Disabilities Act. So what is the Americans with Disabilities Act? Why does this exist? It was first enacted in 1990, so it's not a super old statute. The ADA is a federal civil rights law that prohibits discrimination against individuals with disabilities. It guarantees that individuals with disabilities have the same opportunity as other individuals. So I said it worked, and then, okay. Who's covered under the Americans with Disabilities Act? To be protected under the Americans with Disabilities Act, a person needs to meet 2 criteria. They need to meet the ADA's definition of disability, and the person must be a qualified individual. How is the disability defined under the Americans with Disabilities Act? The ADA lists 3 prongs that a person can fall under in order to be a qualified individual with a disability. You only have to meet one of those prongs in order to be qualified. The first is an individual has to be a person with a physical or mental impairment that substantially limits one or major life activity. 2, the individual has to have had a history or a record of a physical or mental impairment that substantially limited one or more major life activity. So this could be someone maybe who had cancer. Their cancer is in remission. This prong, you don't have to be experiencing any of the impairments related to your disability at the time. You just had to have the history or record of having a substantial a physical or mental impairment that substantially limited one or more major life activity. And then the third prong, is being regarded as having an impairment, whether or not the person actually has an impairment. In order to qualify under this specific prong, you have to show that you are being perceived as a person with a disability, and that you have suffered discrimination as a direct result of the person's perceiving you as being a person with a disability. So those are the 2 things that you have to show in order to qualify under that third prong. Ryan?
So, as Joy said, the ADA was enacted originally in 1990, but since that time, Congress has made several different rounds of amendments to it, and one of those first amendments was the ADA Amendments Act of 2008, and basically one of the major components of that amendment kind of broadened the definitions of disability to be more inclusive, i.e., especially those last 2 prongs that Joy talked about, where someone who has a history of but may not be currently exhibiting or experiencing the symptoms of their disability, or someone who has been regarded in the past as having a disability and been treated differently or discriminated because of that. And basically what that Act amendment said was that you should view disability in a lens when considering whether or not a modification or a requested accommodation is appropriate or necessary or reasonable. You should view that with a lens of that most things that people are claiming are going to be included. It should not be a struggle for the person with a disability to try to have to prove their disability just to get a reasonable accommodation or modification made. And so when we talk about having a disability, the first prong that it has to, or the prong that it has to affect one or more major life activity. Well, what are major life activities? Well, the ADA gives several examples and definitions, which you can see on the screen, but they're really broad ranging, and this is not a full list, but things such as that we do every day, such as breathing, such as talking, such as the ability to see, the ability to communicate your thoughts or any type of mental or cognitive abilities, sleeping, caring for individuals in your household, whether that be a child or an elderly relative that needs help. Caring for yourself is a big one as well. And then also it can include things such as bodily functions, such as your immune system, your digestive bowel or bladder systems, and things of that nature. And again, your cognitive systems are always a big one that can come into question as well. Mitigating measures, what that means is that the ADA says that just because there may be steps or accommodations or prosthesis that a person could use potentially to mitigate or lessen the effects of the disability on themselves, those cannot be considered in whether or not they're regarded as qualifying as a person with a disability. Now, if it's a visual impairment, even if it's a fairly severe visual impairment, but they can be corrected with normal types of eyeglasses or prescription glasses or contact lenses, then that would disqualify someone potentially if that was the only disability they were claiming that they needed assistance with. But for instance, think of someone that may have had amputations before, and they may have prosthetic limbs to varying degrees of style and how they can use them effectively. But if that, let's say for instance that the amputation affected their mobility or their ability to have certain muscle control in one of their limbs, the fact that they have a prosthetic device that helps them better manage the symptoms or the way that amputation affects them does not alleviate the responsibility under the ADA to treat them as a person with a disability. And then the second qualification about who is covered under the ADA, to be a protected person, not only do you have to have a disability, but in claiming an ADA accommodation or modification, you also have to be someone who is a qualified person to receive the services, whether it's of the public accommodation or of the governmental entity under Title II. And really what that means, you can go to that next slide, really what that means is that just because you have a disability may not allow you equal access to a service or program that otherwise you wouldn't be qualified for anyway. An example that I can give would be, for instance, if a person with a disability went into a library and they wanted to check out a book, but the library requires for people to check out books, you have to be a card holder. You have to be registered with the library, whether they actually issue a card or it's electronic, whatever it might be. This person that walks into the library or goes into the library doesn't have the card. It's not discrimination to say, I'm sorry, you can't check out this book. That person wouldn't be able to, under the ADA, claim that was some form of disability discrimination because they were not a qualified person for the program. Now, on the flip side, and we'll talk about it in a little bit though, that's also a good example if the person wanted to get a library card so that they could then be a qualified person and check out the book from the library or whatever piece of media they wanted. The library personnel or service may be required to provide an accommodation or modification to their policies to allow them to sign up for the card. Let's say, for instance, they had a visual impairment. The library staff may have to provide some sort of accommodations to allow them to go through the process of filling out the paperwork or entering in the information on a computer, tablet, or whatever it might be to actually become a registered library guest. That's the other prong, is the qualified individual part.
Okay, so we've talked about what makes you eligible for the protections under the Americans with Disabilities Act. So that covers protections under any of the titles. So you first have to establish that you are a qualified person and you're an individual with a disability. So then we're going to talk about Title II, state and local governments or public entities. So what are state and local governments and public entities? What are they? They're state executive agencies, there are court system, our legislative bodies, towns, cities, counties, emergency services, any services of a town, service, county, school districts, universities, community colleges, VOTECs, regional transit authorities, Amtrak, our public bus system, and any other state or local government instrumentality. So anything that's run or operated by a state, local government, or like I said, also often is called a public entity. And this is a non-exhaustive list as well. So there are some administrative requirements that the ADA has set forth for entities with 50 or more employees. And you're going to hear from the Oklahoma City's ADA coordinator after this. So I just want to touch on these requirements, and then he can touch on what he actually does. So for public entities with 50 or more employees, there has to be a designated Americans with Disabilities Act coordinator. That person's name and contact information must be publicly available. They must adopt and publish a complaint or grievance procedure that members of the public can use. They must publish a notice to the public that includes information about the ADA, how it applies to its programs, services, and activities, and it must be in a format that allows it to be accessible to individuals with disabilities. So that means it might need to be in alternative formats, Braille, other kinds of formats that would enable various people with different disabilities to be able to access that information. And I will just give a shout out to Oklahoma City's ADA coordinator in office. We, for years, have had a great working relationship with the ADA coordinator's office in Oklahoma City, and I think they do a great job. So I'm super happy that we're going to have our ADA coordinator come and speak. So Title II, what does it require? So there is a non-discrimination requirement. So Title II requires that people with disabilities have an equal opportunity to participate in the public entity's programs, services, and activities. It might include architectural access, reasonable modifications to policies, practices, and procedures, and effective communication. And we're going to be talking about each of those things individually as we go forward. And all of the entity's programs, services, and activities must be in the most integrated manner appropriate. So the most integrated setting is one that enables individuals with disabilities to interact with non-disabled individuals to the fullest extent practicable. This principle is known as the integration mandate, and it's central to the ADA's goals of ensuring that individuals with disabilities have equal access to services and opportunities. This mandate was articulated in 1999 in the landmark U.S. Supreme Court case LC versus Olmstead. That case had, and I can't even describe the impact that that particular case had for individuals with disabilities. States, local governments, and other things had to come up with a plan that talked about the integration and how they're going to integrate individuals with disabilities. What are they going to do to their service? There's an Olmstead plan for Oklahoma that you can go on and find out. Its impact is just insurmountable, if that's the right word or not, but it was huge. And so really core to the Americans with Disabilities Act is the equal opportunity and the opportunity to be amongst people without disabilities to the maximum extent appropriate. So how might a state violate this, or a county or a city violate this particular provision? So governmental entities who contract with sheltered workshops, I don't know if you all are familiar with sheltered workshops or not, I see a couple of people nodding their heads. They are an environment that employs individuals with disabilities separately from people with disabilities, often paying less than subminimum wage. So versus in a public entity contracting with employers who provide community integrated employment, and that is work for individuals with disabilities in the community right alongside individuals without disabilities. Not only that, they're compensated at the same rate and same benefits as non-disabled peers. And that is not a benefit that individuals get working in sheltered workshops. So that might be one violation, is state and local governments, entities contracting with sheltered workshops.
So Title II of the ADA also requires that governmental entities, local and state level, have architectural accessibility. And that means that all of their public entities' programs must be accessible to the public, but to all of their facilities. So one example of that is, for instance, this meeting tonight. If for some reason this room wasn't ADA compliant, and there was an individual or individuals that wanted to attend the open meeting tonight, and they let the city know ahead of time, let the commission know ahead of time that they weren't able to access this room. The commission would not have to make necessary physical modifications to the room before the meeting. They would be able to, as long as they were able to hold the meeting in another public space where it was accessible for the individual and other individuals with disabilities, that would meet the requirements under Title II of the ADA. So especially when you think about cities and municipalities that have been around for a long time, and in the state specifically. A lot of these buildings were built a long time ago. And even with updates and amendments, a lot of those were made before 1990, before the ADA was enacted. So as long as there is an alternate place or facility that program or service can be provided, then that will be in compliance with the ADA. And so buildings and facilities that were constructed before the ADA went into effect in 1990 do not have to, are not required to comply fully with all of these standards, as long as they have that alternate location or alternate facility that they can provide the goods or services at. The public entities must design and construct all new and altered buildings, however. So anything built after 1990, when the ADA was enacted, any new construction or major alterations do have to come into compliance with the standards. And there are two standards that really mainly control it for under Title II. One of those is the 2006 ADA Standards for Transportation, which was issued by the Department of Transportation. And most of these requirements are things such as access, generally speaking, like accessible walkways to and from the building or facility, detectable, audible, or other types of warning signs at crossings or at curb cuts and things of that nature, and bus stops. Bus stops or train stations. You have to have audible and or other types of signage and notifications that would allow people with disabilities to be aware that the service is offered at that place and what the dangers and the appropriate places to be are on or at that facility. And then the other architectural accessibility standard that's widely used and that cities have to pay attention to, municipalities, is the 2010 Standards for Accessible Designs, which the U.S. Department of Justice, the DOJ, issued in 2010. And these are more of the standards that you think about in having widened doorways, for instance, or widened aisleways so that people that are users of wheelchairs might be able to get through, and appropriate signage in the building for exit signs and emergency notifications and things of that nature. And then the question of what are facilities, when we talk about, well, the Title II covers the facilities of state or local government. Those are almost anything you can think of that's a physical structure, basically. It's not just the buildings and structures, which is kind of the big thing that you think of, but also the complexes, the land or the other appurtenances that go with a particular building or facility that is used by the government that the public has access to. That could include the roads and the walkways and their parking lots. And again, when you're talking about a structure, let's say you have a city park, and you have accessible design, and it's a new city park, so you have accessible design on like the playground equipment for children and whoever wants to use that equipment. It's not enough just to have the equipment be accessible. The park surrounding it, the area surrounding it, from the parking lot to that equipment also has to be designed to be accessible as well, to encompass many different types of disabilities so that everyone has equal access to that.
Okay, reasonable modifications. We mentioned this earlier. Reasonable modifications must be made to policies, practices, and procedures when necessary to ensure equal opportunity, unless doing so would fundamentally alter the nature of the program, service, or activity. So examples of some program modifications would be no animals permitted, service dogs are allowed, assisting people with disabilities filling out applications, allowing extra time for inmates who use TDY or video relay services. Another example might be if you're not allowed to bring food into a building and someone with diabetes needs to bring food in, you're going to have to allow them to bring food in. So when might a modification be unreasonable? When it is a fundamental alteration of the nature of the program, service, or activity. So this occurs when the change is so significant that it alters the essential nature of the public entity's services, programs, or activities. So an example of this might be if the city is on a beach and they have a beach volleyball tournament that they run, and they get a request from an individual that's in a wheelchair who wants to participate and ask them to move it inside, that's probably going to fundamentally alter the nature of the activity, as the activity was beach volleyball. Another example might be accompanying and assisting an individual who uses a wheelchair at a museum. May not be reasonable if there's only one person on staff and they need to watch the register. It may be reasonable and would probably be reasonable if there was more than one staff. Another example would be if an individual with a disability needed assistance eating at a hot lunch program. If they don't provide assistance eating to other individuals, that may be a fundamental alteration as well. Another time when a modification might be unreasonable is when it's a significant financial or administrative burden in context of the entire organization's resources. So we've gotten a lot of these over the years where, especially when it comes to American Sign Language interpretation, and if you all have ever hired an ASL interpreter, it's not a cheap endeavor. And so we've had many people who've called and said, I'm sorry, the public entity said we can't afford it, so we can't do it. But just say for like Oklahoma City, if that happened in Oklahoma City, you would have to look at the Oklahoma City's entire budget to determine whether or not that was an unreasonable administrative or financial burden. So, when you're looking at governments, public entities, things like that, those are going to be much more difficult to prove that unreasonable financial or administrative burden. And the third reason a modification might be unreasonable is if when participation by a person in the service, program, or activity poses a direct threat to the health or safety of others. So this might come into play. We actually had something like this several years ago where we had an individual who was in medical school who made it all through all the classes and everything like that. He was asking for extra time because it took him extra time to read and process. However, when they got to clinicals and rotations, and when then there was a request for extra time to perform life-saving procedures, that's going to probably pose a direct threat to the health and safety of others. And so that was deemed a direct threat, and they were unable to continue participating in the medical clinic because of that.
So another thing that's required of state and local governments is effective communication. State and local governments are required to ensure that the communication with people with disabilities is just as effective as it is for those without disabilities. Some examples that we can think of is alternate formats of standard documents. We talked about the library example earlier. If the library generally just has one form which you sit down and you fill out, but you have someone who's visually impaired, they may need to make that, have a screen reader available or have some other form way for the person to fill out that form. It may be again, it may be just another person assisting them do that. Auxiliary aids and services, you can have text-to-speech devices, you can have screen readers, and as Joy mentioned, ASL interpreters are often the type of accommodation that a person will need. And then accessibility of websites and mobile apps. So if the state or local government has a website or multiple websites or applications that they use for any number of their goods or services, or even for just informational purposes about the activities of the government, those have to be accessible. And we'll talk a little bit later about the new accessibility guidelines that have come into place that the city and the state will have to come into compliance with. But accessible websites is a big one now in this world, as we're all on our readers and our phones and our tablets. That's something new that came about since the ADA was enacted. So the choice of what is an effective form of communication or is an effective communication under Title II for an individual with disability really rests with the individual with the disability. The state or local government is required to give primary consideration to their preferred method of communication. And what that means is that unless there is a legitimate burden or financial reason that this, and it's a hard hurdle to overcome for the state or local government to be able to show, they have to provide the communication in the form that the person with the disability is most comfortable with. For instance, when we talk about ASL, it's a very good example because a lot of speakers of ASL may not be able to read and write the English language. And so just saying, well, we're not going to provide an ASL interpreter for you, but we'll get a text-to-speech or some type of screen reader device that will that you can read along. It'll be like a closed captioning device. We'll provide that. That may not be effective because they may not be able to understand or engage in that communication because they don't read or write the English language. But ASL, which is a different form of communication that they're fluent in, is in fact the type of accommodation that they need, and the state or local government will be required to provide that under almost any circumstance. So when do they not have to provide the requested accommodation or particular mode of communication? And again, much like we talked about when Joy was just speaking a moment ago, if there's an undue burden that would negatively impact or alter the program, service, or activity, or result in a financial hardship on the municipality or government. Generally speaking, whenever we see come up against these arguments, it's almost always a question of money, to be honest with you. But even if they can prove that that burden does exist, they still then have to provide the next best available form of accommodation for that type of communication for the individual. And then as we were talking about, in April of last year, Congress enacted, the Department of Justice issued final rules outlining the specific requirements for how to ensure that your web content for a state or local government and your mobile app access is accessible to people with disabilities. And the states and local governments must come into compliance with this. And because of the size of not only the city of Oklahoma City, but the state of Oklahoma, we have until April of next year, of 26, to come into compliance with these web accessible designs and any type of computer or mobile access apps must be in compliance with this act.
All right, we're going to talk about enforcement and remedies available under Title II. Under Title II, private parties can file a complaint with the following. They can file a complaint with the Department of Justice, and that must be filed within 180 days of the alleged discriminatory act. And one thing I didn't put on here that we are going to talk about, because I want to give an example, is with the local ADA coordinator for the public entity. So a few years ago, I had an individual who contacted our office who was blind, and he was having problems with the airport, with the Will Rogers Airport. The different airlines had taken away curbside service, and so he was having a difficult time being able to get from his car, from when his wife dropped him off at the curb, into the ticket counter. And then the other major problem he was having was with accessibility of their website. It was not accessible with his screen reader, which is the only way he was able to access content. So he actually contacted us after he had filed his grievance with the city's ADA coordinator, and it was kind of elevating a little bit, and so he called our office asking for some assistance. And so we got involved and had some conversations. By that time, the city's attorneys were involved, as well as the ADA coordinator. The airport staff was involved at that time, and really were able to use that process to sit down and have a conversation with the airport. Took a little finagling to get them to sit down and talk to us. But when we actually got down and had a conversation, I had my client bring in his screen reader, and I had them bring in, all of their IT people came to the meeting to talk about, because I was like, if you don't see it, you're not going to understand what the problem he's having. And through that grievance resolution process, we sat down with the IT department, with the people from the airport, and were able to demonstrate to them the actual problems he was having accessing their website. When they saw it, they were like, oh, wow, we had no idea that this was an issue. And so they actually allowed my client to work with the IT folks and work through those whatever the internal problems that they were having with the website accessibility. And so my client was able to explain to them, to show them, and as they were making changes to their website, they were able to use him to make sure that it was accessible visually for him. And then we also were able to talk about the problems that he was having being able to get someone to get him from the curb into the ticket counter, because there was some controversy between it was the airline's job to do that, it was the city's job to do that. Anyway, there was whose responsibility was it? And they took responsibility, and shortly thereafter, actually, all of the airlines reinstated curbside service. And so it was a great process. He was able to start the process himself when he started to have some problems because they weren't understanding what his issue was. And so we were able to take that on and really get down and have that sit-down meeting. And it was a great resolution. And as of now, did you have something?
Yes, I do. That's federal, what you're talking about is something that's federal. What about state? Like, what if you're talking about somebody coming in from a different state with a driver's license, and it's valid, and they take your money, they take your picture, but they give you a packet for you to go to a doctor, and you have to pay for it, and for them to, and it's 60 days until I can get my driver's license. But that's state. Would that be different in Oklahoma?
No, but we can talk about that afterwards if you have a specific question about that. So we'd be happy to talk with you afterwards. All right, moving on, additional enforcement remedies. So right now, private parties may sue for damages under Title II. The ability for private parties to obtain damages under Title II was affirmed in 2004 by the Supreme Court case of Tennessee versus Lane. Prior to that, private parties were not able to sue and get money damages. This case, the plaintiffs were actually represented by an attorney from the Tennessee Protection and Advocacy Agency, which is our sister agency, along with other private counsel. This particular case centered on the experiences of Lane and Jones, who faced physical barriers to accessing Tennessee courthouses. Lane was a defendant, and he had to crawl upstairs in order to get to the courtroom. And the court reporter, Mr. Jones, was unable to attend hearings due to the lack of accessibility of the courthouses. So, as I said, prior to this 2004 case, money damages were not available to private parties. So, because of Tennessee versus Lane, plaintiffs may now recover compensatory damages upon showing of intentional discrimination. However, punitive damages, meaning damages simply are meant solely to punish the defendant rather than to make the plaintiff whole, are not available under Title II. The courts may also issue what's known as injunctive relief, which means a court can order the government to make a particular modification or offer a particular auxiliary aid or service. Brian's going to talk about one of the cases that we handled under Title II recently.
So a really good example of that from our office that was a really interesting experience. When I first started, there was a litigation filed by our office and private law firm and the National Association for the Blind against the state capitol. This person was a person who was deaf, profoundly hard of hearing, deaf, and really was engaged in the political process, liked to go to the Capitol on open days and sit up top and listen to the debates and listen to the bills and resolutions that were being brought before the House and the Senate, liked to go to both chambers, but found out pretty quickly that it was not very accessible for him. He couldn't hear what they were saying. They didn't have any type of closed captioning or ASL. They did, the Capitol, the Senate has its own ADA coordinator and the House has its own ADA coordinator. And if you've ever dealt with the House and the Senate, they manage their business differently. And so he had approached both of those people before filing the lawsuit, before contacting our office, and had said, hey, you know, I would like to come to these sessions. I would like to be able to participate in these sessions, and I need an ASL interpreter. And they said, well, we'll see if we can get one. And this went on for months. He filed his grievances. He followed all the appropriate administrative processes. Finally didn't get anywhere. So cut to, a lawsuit was filed. Injunctive relief that we were seeking in the lawsuit was to enjoin or stop the House and the Senate from failing to provide these accommodations. And so after a period of some discovery and back and forth negotiations, we did get to a federal court mediation, which is where we sit down with a U.S. magistrate, not the actual judge that has the case, but one of the magistrates, and sat down for about 8 hours, 10 hours between all the parties and hashed it out and finally did reach a settlement. And now under the settlement, this, as long as you give, I think it's only 24 hours advance notice, but if it's shorter notice, they will make every reasonable effort to provide an ASL interpreter. A person who's hard of hearing or deaf can ask for an ASL interpreter to be with them when they're viewing Senate or House business. Closed captioning, you can watch most of the House and Senate proceedings on they have a web page that you can stream it live, and they're required to close caption all of those sessions and presentations now. And even so far, we were able to even go so far as to get them to go back into their archives. We were talking about it today, I can't honestly remember, but it was 3 to 5 years back that they had to go to archive all of those and provide closed captioning, but said that if someone wanted to watch a particular session that was older than that, whatever that time frame was that we agreed on, if someone wanted to watch that, if they were given, if the Senate, House or Senate was given a reasonable amount of time to get that closed captioning attached to it or the transcript with it, they would do that. So that's an example of how we sought an injunction, an action from the court to actually make the state do or do not, do something or stop doing something. And that was how, through the settlement, we got injunctive relief, essentially, for the client for effective communication. So the next section, we're going to go through a little bit more quickly because I know we're burning through some time, and because this deals with Title III, which is public accommodations, so it's not necessarily restricted to state and local governments. This is the part of the ADA that we might think about that we encounter in our everyday life. And public accommodations, what is a public accommodation? Think about almost anything that's not a governmental entity or service. So you're talking about hotels and restaurants, bars, places, parks and recreation areas that are privately owned, like an amusement park. The zoo, if it's a private zoo, or an aquarium that's not owned by the city or the state. Senior citizen centers, hospitals, daycare centers, all of those things would qualify. There's a number of things listed on there, and if you've been there as just a private patron, it's probably covered under Title III of the ADA. So the non-discrimination requirement under Title III is that public accommodations are required to make reasonable modifications to their policies, practices, and procedures in order that their goods and services are available to individuals with disabilities as equally as they are to those without. And we'll get to this in a second, they are to provide those goods and services in the most integrated setting. An integrated setting, as Joy spoke about earlier, means the setting that's most typical of any other person without its disabilities interaction with that good or service. So in making those reasonable accommodations, a couple of examples would be if a restaurant, for instance, has a no pets policy, but an individual uses a service dog. The restaurant would have to allow that service dog into the places where the general public is allowed in and make a modification to that no pets policy by allowing the person and their service animal in. And in thinking about, well, what would that mean from an integrated standpoint? We see lots of bars and restaurants now where you can go and they have an outside patio, especially in the spring and the summer and early fall. You know, we've got nice weather in Oklahoma. And sometimes they'll allow pets out there. But for a restaurant to say, oh, well, you can bring your service animal, but you need to sit out on the patio where we allow pets. That's not a reasonable accommodation. If that individual wanted to go in by themselves or with their friends and family or whatever and eat inside the restaurant, then under the Title III of the ADA, they're required to allow them in and make that modification to their policy. Another example is people who have mobility issues. If there's a park or an amusement park that says, hey, we don't allow any type of motorized vehicle, we don't like people riding their little mini bikes, or you can't ride Segways and those kinds of things here, they would have to make a modification to that policy to allow someone that used a motorized wheelchair or scooter device for their mobility issues under Title III of the ADA. With regard to auxiliary aids and services, kind of like we talked about under Title II, places of public accommodation, so restaurants, shopping centers, or individual establishments, clothing stores, whatever it might be, they have to make their aids and services and the communication with people just as it would be with those without disabilities. And because the nature of communication may vary from business to business, the ADA allows for flexibility in some of these situations and effective solutions. Did we skip one?
No, that's my turn.
Okay.
All right. So flexibility, let me see. Oh, yes. Okay. So for example, Brian's talking about flexibility. While some places of a public accommodation, like a doctor's office or a lawyer's office, are required to provide services like American Sign Language interpretation for deaf patients because of the nature and complexity of the communication, places like restaurants, it may be sufficient for the employees to take a person who's deaf and take their written order as opposed to having to get an ASL interpreter. It really depends on the complexity and the nature of the communication that's required. So some further examples of auxiliary aids and services in places of public accommodation are performance venues allowing deaf customers to purchase tickets online instead of over the phone, a store providing a clerk to assist a person with a wheelchair to reach items that are out of reach. It could be helping people fill out paperwork. We talked about that. There's a lot of similarities. There's actually not many differences between Title II and Title III as far as like the definition of auxiliary aids and services and modifications. How they apply is a little bit different. And so that's the next thing that we're going to talk about, because we talked about under Title II that state and local governments must give primary preference to the individual on what method of communication they want to use. Under Title III, who gets to determine which auxiliary aid and service will be provided is different. So Title III public accommodations is encouraged to ask the individual for their preference, but they are allowed to provide an alternative aid or service as long as it is equally effective in providing access to goods or services offered. And let me tell you, that we get a lot of calls about that, and especially from the deaf community, because in hospitals we've had multiple, which I don't understand why hospitals are reluctant to provide ASL interpreters, but they a lot of times would like to provide like relay services where basically a person, the deaf person, would be speaking through a computer to another, to an interpreter, and then the interpreter would speak back. They talk about having a lot of issues with internet access, and then there's delays, and it causes a lot of problems. Or they'll want to use closed caption, which again, due to that complexity, is probably not effective. But we do, over the years, we've gotten a lot of calls about those issues. So because there's that equally effective, there's going to be some controversy between the Title III entity and the individual, which might require someone to reach out for legal services.
And then under Title III, much like under Title II, places of public accommodation are required to make their buildings and access ways accessible. So the architectural accessibility requirement talks about making things readily achievable to remove the architectural barriers. And what that means is as long as they can be accomplished without much difficulty or expense. And again, oftentimes when there are controversies, it comes down to whether or not the business claims they can afford to make the modification or not. And whether modification is readily achievable will often depend on the size or resource of a business. I think we talk about it again in a minute, but think about a local store that was started up by an entrepreneur that may sell a good or service versus like a Walmart or a Target or a big chain store like a Best Buy or something. It's more likely than not that the larger store is going to have to be more creative in making the accommodation and have a bigger requirement to make that accommodation or modification to an architectural portion of their building, regardless of the expense, than maybe a smaller business might. The removal, some of the examples of what you could do to make a business readily achievable is providing accessible routes from the parking lot to the entrance. For instance, so thinking of a private business, think of maybe like a wedding venue that's kind of rustic and out in the middle of a less populated area, like a destination wedding venue, and they have a nice, really pretty kind of old-timey dirt and gravel walkway up to the chapel. However, for a person with a mobility device that maybe not would work very well on that type of substrate, like a cane or a walker or some type of mobilized scooter, that entity may very well have to provide some type of paved access, even if it's to another part of the building, as long as it's access to the entire building to receive that good or service. Installing entrance ramps is a big one that we've seen around. They're pretty common now. Widening doorways to make sure that people with their mobility devices can get through. And then simple things such as repositioning of shelves and furniture. If you have a business that likes to put boxes right in their doorway with all their pretty books or whatever they're selling, but they've got it kind of narrow so it catches your eye, but you might not be able to get through if you have some type of disability that affects your movement or ability to get through that doorway or entranceway. Simply moving those further apart is an easy and inexpensive way that they could reasonably accommodate that person and make what is essentially would be considered an architectural accessibility. When removing these barriers, businesses are only required to comply with the ADA design standards to the extent possible. So if there's not enough space to install a ramp, for instance, the business may be able to, and when we say not enough space to install a ramp that meets with the gradient requirements of the ADA, they may be able to use a shorter amount of space and still install a ramp that may not meet those requirements, but if it's the next best alternative and it's still safe and effective for the individual to be able to access the business or the goods or services, then it would be acceptable. When a business, even one built before the ADA went into effect, makes an alteration to its facilities, those alterations must, to the maximum extent possible or feasible, be accessible. Just like under Title II, there is an undue burden consideration or defense potentially for the business. They are not required to make an accommodation if it would cause significant difficulty or expense. And whether that expense or that accommodation is unduly burdensome will depend on the nature and cost of the accommodation and the overall financial resources of the business. And this is that example where we talked about it may be provable or it may be acceptable for a business that's a small business to say, I really can't do that. There's no way for me to install a ramp to any of my access points that would make it accessible. We'll try to come up with another accommodation, but there's no way that we could budget for that to be done. We've gotten bids, and it's just not feasible. Versus, again, a larger box store business or a chain store that is a part of a corporation that has larger funds and more ability to make those accommodations or alterations to their facilities.
Okay, we're going to talk about enforcement and remedies under Title III. So private parties can file complaints with the following: the U.S. Department of Justice, again, within 180 days of the alleged discriminatory act. And also in Oklahoma, you can file with the Oklahoma Attorney General's Office, Office of Civil Rights, within 180 days of the last act of discrimination. Private parties may bring lawsuits to enforce Title II. They may receive what's called injunctive relief, and we talked about that earlier, that meaning that a court can order a business to remove a barrier, provide an auxiliary aid or service, provide a certain modification. However, private parties cannot be awarded money damages under Title III. However, if they do file a lawsuit and get injunctive relief, private parties can be awarded attorney's fees and costs. The Department of Justice, on the other hand, can bring a lawsuit against businesses for Title III violations and can seek civil penalties, which can include monetary penalties along with attorney's fees and costs. We had, a few years ago, I'd filed a complaint with the Department of Justice. They did decide to pursue that and actually were able to get monetary penalties and awarded some of that directly to my client. I don't think that's super, I don't think that happens a lot. It's only happened once in my almost 25 years here, so, but it is a remedy that's available.
How are we on time? Because we have, I don't know if we want to do this section or if I want to make sure there's time for the ADA coordinator and.
What time did you, I think we started about quarter after?
Yeah.
Yep.
Absolutely.
Absolutely. Yes, and so all these slides are available for, 'cause we just wanted to make information available for service animals and emotional support animals under Title II, Title III, and under the Fair Housing Act. So that information is available. Great, thank you.
Thank you.
I was hoping there was a screen up here because there was no way I was going to remember all that. Okay, so my name's Scott Hodgson. I'm the newly appointed ADA coordinator for the City of Oklahoma City. My official title is the right-of-way specialist. So basically my career at the city, I started in public works about 16 years ago. And I promoted, I think my bio says it, from an inspector up to a chief and to the assistant superintendent of field services. Recently, the ADA coordinator retired back in January, and I assumed that position. But the reason I was qualified for the right-of-way specialist is the bulk of what I've done for public works was accessibility in right-of-ways. So I have a good deal of knowledge in that. But you can go to the next slide here. So the City of Oklahoma City does not discriminate on the basis of disability in the admission or access to or treatment or employment in its programs or activities. It is the policy of the city to ensure that communication with participants and members of the public with disabilities are as effective as communications as with others. So the importance of our standards, accessibility, I mean, these are some of the needs that we're trying to meet with our accessibility. It's broad, it's a lot more than that. But this was just trying to give you an idea of what we're looking at in design and enforcement. So next slide. So some of the things that we do to try to be proactive in compliance is in plan review. It says I've reviewed 1,000 plans in a year. It's a lot. So these are anything from private development projects to streetscapes, road widenings, municipal buildings, those kind of things. But it's not just me. Plan review is a team effort for the City of Oklahoma City. You have Planning Commission that looks into things, grants, these kind of things. You've got developmental services that are looking at codes and enforcements on designs of buildings. Public Works has a team of people, Tech Review, that has a lot of hands in review. So it's a team effort. But one of our goals is to be proactive in design, so maybe we can catch some issues. Maybe there's some grades on roads that aren't going to be friendly to accessibility, and we can have those discussions in design before it comes to the field. Next slide. So I thought it'd be kind of fun to show y'all some of the stuff that we look at when I do a project final or a field audit, you might call it. These are the things we're looking for. Once again, it's not just this. There's more things. But I thought I would give you some whoops and some good jobs on some slides here. If you can give me a slide here. So obviously we've got a barrier in the left picture. It's probably not the most accessible pathway. We don't always get it right. If you can stay there on the second. So the one on the right I don't know if some of y'all might recognize that, but that is the new Britain Road streetscape. I don't know if y'all been up there, but they did a great job in design. There's a lot going on there. You got companion area, you got seating, on-street parking, you got accessible paths, and you were dealing with a lot of grades, a lot of old structures that we're trying to combine new work into the old stuff. There's a lot of thought and process in design and construction. Oklahoma City is very fortunate. We've got some of the best contractors out there when it comes to compliance. And over the years, I've watched the ADA and the construction improve greatly. And my gosh, I mean, I'll show you a slide here in a minute. I don't know what was going on, but there's things that we've done. Contractors are now required to be ADA certified. So Public Works, and along with the previous ADA coordinator, they got together and designed a certification program through the community college, Oklahoma City Community College. And contractors have to go through the certification program to be a qualified paving contractor for the city of Oklahoma City. And it's taken a lot of the learning curves out of it. They'll actually understand what we're looking at and what we're hoping for in design and construction. But that was another side note to how we're trying to be proactive in accessibility. Next slide. So the ramp on the left's pretty rough. It's pretty much unusable, you might say. Like stated before, ADA came out in 1990, and in 2008, Oklahoma City in the right-of-way stuff, we build to what is called PROAG. All right, so PROAG is a part of ADA. It's been adopted by 6 of the federal functions. There's still two leaning, but PROAG stands for Public Right-of-Way Accessibility Guidelines. So whenever we're building streetscapes, doing compliant paths, going along stuff, we use the PROAG guidelines. They largely mirror ADA. Some of it's a little bit more friendly for construction with different grades and running slopes. One of the big things is a running grade of a sidewalk in ADA is a 5% running grade. Anything above that becomes a ramp, and you have landings and other things like this. PROAG recognizes that sometimes it's just difficult when you're in a hilly, like eastern half of Oklahoma City, lots of hills. You can't necessarily keep a sidewalk less than a 5% running grade. You just can't do it. It's unconstructable. PROAG says your sidewalks have to be 5% running slope unless the grade of the road is higher than that. So if the road grade is running at a 7% slope running grade, the sidewalk can be the same as that, but it can't exceed what the road is. So it makes construction more feasible for a lot of, environmental difficulties. But, this right here, that ramp, if I remember exactly where it's at, that was most likely it's the old part of town. Early on, ramps were just like, let's just put a piece of concrete on there and let's go. It's not like that right here. So if you notice on the right, that ramp was built, I'm going to say about 3 months ago. It's in a neighborhood and a resurfacing project. But if you look, there's been a lot of design going into that. So you got an elevated yard. So we've built a retaining wall on the back of it. That's a type B ramp. It's coming in flat for good cross slopes, got a landing, and we're transitioning into an existing sidewalk. That's just an example of a well-designed ramp compared to what some's out there. Oklahoma City is a big city. It's 640 square miles roughly. And that would be hard on anybody's budget, right? I mean, you could have New York's budget and struggle with that square footage. So next slide, please. Okay, here's an example of two crosswalks. And honestly, I've driven by the one on the left 1,000 times. and I just noticed this a couple weeks ago. These crosswalks right here are actually 1.5 miles apart from each other. If you notice the one on the left, yeah, it's got the crosswalk bars, but if you look, there's no accessible ramp on this side, and there's nothing really on the other side. Why it got built like that, I don't know. It's before my time, but obviously it's not an accessible crosswalk. The one on the right, if you look at it, the ramps are straightly aligned. It's good striping. The individuals are protected. If you'll notice the pedal button on the left, it's fairly reachable. Obviously, there's not even any ped poles on the one on the left. The one on the right does. So, next slide. So here I wanted to point out two vastly different situations. So this is an older crosswalk on the left. You can tell by we've changed our markings for crosswalks to an international. But if you see in the middle of that island, there's a ped pole. So the person would have to get up, walk across the curb 10, 15 feet to the ped pole. If you're going to walk that far, you could probably just make it across the intersection, right? The one on the left is also at that same intersection we were talking about earlier that was on to the side. If you notice, I got a ped pole, and it's got an extension off of the pole. So we shoot for a landing area by a ped pole is supposed to be 30 by 48. We usually try to do 5 by 5 as a city. The city's pretty proactive in trying to exceed minimums. But if you notice that extension on that ped pole, we have a spec where it has to be no more than 10 inches. So if you look at the face of the curb, if you were to run a level straight up and down, it would be less than 10 inches to touch that button. And that's for side reach for somebody in a wheelchair. That's the reason it's at that 10 inches. A lot goes into the design of these intersections. Next slide. So one thing we got to look for is when we're doing construction, and mainly downtown, with the old Myriad coming down and the new Paycom, there's going to have to be, accessible routes derived through that whole demo process. It's difficult to work with. It's an evolving thing weekly. I've had like 4 meetings out there already to talk about accessible paths. We try to do everything we can. They're supposed to be marked to let you know that that's an alternate accessible path going around the construction. These are one of the things we look for when we're out in the field. Next slide. So the one on the left is a new bus stop, but we don't always get it right. And contractors don't always get it right. So if you'll look at the end of the bench inside that bus pad, that's the companion area for somebody in a wheelchair to be next to the bench. That's got to be a compliant, less than 2% cross slope both ways. The companion area itself is compliant, but if you look right in front of it, there's a drop down for the accessible ramp. Well, that's not a good design. So this is something that I had the contractors remove and replace because that's a trip hazard. So while the companion area was right and the ramp is right, it didn't work because of the design of it. So we're not perfect, but we try our best to make things right as we see the issues come up. One on the left, that is y'all might be familiar with it. That is a BRT bus stop up there on Northwest Expressway, just to the, I believe, the west of Portland. The BRT was a lot of challenges in that. You're dealing with a lot of grades, working with bus stops with platform alignments and all that. A lot of utilities are having to be moved. There's a lot of investment in each one of these stops. And between the designing engineers, Public Works, COPTA, it was an amazing project. And the use of it for accessibility for everybody and just the speed of it, it's a pretty amazing project in itself. Next slide. Another thing we're going to look at is, this is a train station on Automobile Alley. I just stopped because I enjoyed the picture, took a picture of it getting used. I was actually there on an audit on another ramp on another corner of that intersection and thought, you know what, that's a good looking train stop, and it shows the usability and it being used. So I was just appreciative of the thing, so I took a picture of it. Next slide. So ADA compliance for city buildings is, you know, we try to build to the most current standard at the time. These buildings, this is the police headquarters. I think it's probably about 10 years old now. I think there's another slide of, go to the next slide. The city courts. I was actually there 2 weeks ago measuring force on door openings. Some of them exceeded, you know, ADA requires a 5-pound opening force on a door. We had some of them that were a little more than that, so they're having to be adjusted. So I do go out and I take a look at that stuff whenever it needs to be, or it's brought to my attention that there's a concern. Next slide. The new constructions, people don't think about it. When you see a fireman, you're not necessarily thinking ADA compliance, you know, but we have to build to that. You don't know who's going to be in there. They could have a family member visiting or anything else. So even facilities like the fire stations, we try to make them as compliant as possible. Next slide. So this will forever be the Hall of Fame Stadium to me, but I guess it's called the Devon Center now. I don't know how many of y'all enjoy watching our Sooners play softball. I really enjoy it, but this particular park field has had so much work done in the last few years to continue that contract with NCAA. But there has been so many improvements in accessibility at this facility. It's just, when I walk out there and I just see what's all happened in the last few years, it's a proud moment. I mean, we've put in an accessible elevator because there was no stairs. It's just the amount of work that the city has done in design and everything, and it's not just the city, obviously, it's engineers and architects and all that, but anyway, if you go to the next one. So this is the grievance procedure that they were talking about earlier. The city of Oklahoma City has established this grievance procedure to ensure a prompt and fair resolution of complaints related to actions prohibited by the U.S. Department of Justice regulations and enforce Title II of the Americans with Disabilities Act. Title II specifies in part that no otherwise qualified disabled individual shall, solely by the reason of such disability, be excluded from participation in, denied the benefits of, or subjected to discrimination in programs or activities sponsored by the public entity. So here's our grievance procedure. Complaints must be written, include the complainant's name and address, describe the violation, and be filed within 30 days of noticing it. An ADA investigation by the ADA coordinator will occur, gathering input from all parties with written determination provided within 60 days unless delayed. A reconsideration from the city manager can be requested within 10 days if dissatisfied with the options available for the disabilities. So here's the accessible website we were talking about a little bit earlier with my peers here. So this has been updated. The whole website for okc.gov has been updated in the last month or so. But my name has replaced the previous person's name, and my contact information has replaced the previous ADA coordinator's name. It does have a, I believe, if you look on the link, I can't see it on that picture, but once you go to government, you can go to accessibility. Further down underneath where it says accessibility, it says the grievance procedure, and there's a Adobe linked form where you can actually fill out your grievance, and then it gets sent to my department, or me now, Like I say, it's just recently been updated to me, but next slide. So here's my information. That's my office phone number, my email, and that's where I office out of. So in a nutshell, that's what I do as an ADA coordinator. Obviously, I could probably go on for quite some time, but I was trying to keep this short, so I appreciate your time.
Thank you, Scott, and thank you, Joy and Brian. So informative in an area that involves very crucial human rights for many, many residents and visitors of our city. So thank you. We've exceeded the time we had allotted for this program. I promised to carve out a bit of time for a question. We can take probably one question if you're not going to be able to stay afterwards to visit with our speakers.
I just noticed, oh, of course, like sidewalks in the city are not consistent forever. Is there a plan for sidewalks to ever be consistent in neighborhoods across?
I'm sorry, I couldn't hear.
She's asking about sidewalks in neighborhoods. And is there a plan for those to be restructured to be compliant?
So the city does have a 50/50 program for sidewalks that are non-compliant, but for the most part, it's a resident's responsibility with what's in front of their house. Anything that's newly constructed will be compliant. And so a lot of the developments, at the time of the development, Public Works makes sure that the paving contractor that's doing the work will do all common area sidewalks and common area ramps along the frontage roads and whatnot, but the individual sections per house are usually built with the house. So you get segments, the neighborhood is complete, and then you'll have unified sidewalks.
Yeah, the trouble is we're in the same, where there are renters or owners, I'm disabled myself, I don't look like it, but I up and down these days. And it's very difficult to walk on streets and just talk back and forth constantly. And if there's any way to make more public comments about, future initiatives, are there ways to direct comments that other people can maybe vote on or that type of thing? Sorry, I made this go.
It's fine. When we come in and do say a resurfacing project, we'll take on a lot of those sidewalk issues. Obviously, and I don't want to speak for Public Works, I'm not part of Public Works, but typically when we do go in there and do a resurfacing project, we try to make all the ADA upgrades, ramps, anything, settled sidewalk, ramps on. We try to address all that issue within that, scope of that work, the boundaries of that particular project.
So, one, I don't know if you've tried to talk to James Cooper, because I assume he's your council person, but right now the city's going through a 2025 general obligation bond process, which is basically once a decade, we do all of these infrastructure projects that allow us to leverage property taxes, which otherwise the city can't do. And some of those include sidewalks. And so council just approved a vote October 14th. And so we will be doing a host of community engagement events, which will include all of the proposed projects. And so I encourage you to look on our website, because you'll be able to see a map of proposed projects and then also see, okay, maybe it's not in the bond, but is it part of MAPS 4, but it hasn't been constructed yet. We also, again, we'll just have public comment and meetings to discuss those. So another chance for you to give some public comment, hear about what's coming, and then ultimately, hopefully, vote on the 14th.
Your Paseo district might unify around this issue too. So Scott, Joy, and Brian, they are now know by you. You can reach them. They're experts, and they really care about these issues, and they've devoted their lives to helping people fully experience and enjoy everything we have to offer in the city. So let's applaud them for their work and thank them for being here. Appreciate it very much. Because we're running so late, we're going to take about a 3-minute break just to rearrange here, and then we're going to proceed with our agenda for the Human Rights Commission. All right, well, there's a lot to think about and a lot of action to take in this area, so I hope you all enjoyed that program. Let's move now to the rest of our agenda, and we will take up now item 4A, approval of the minutes from our meeting on March 26, 2025. It's been a while, hasn't it? Our May meeting got canceled, so it's been a while since we've assembled. But we do need to review and approve the minutes of that meeting or make any amendments that are needed. And I will entertain a motion from the commissioners.
So moved.
Second.
Motion has been approved, and there's a second. All in favor? Okay, Barbara Peck made the motion, and Marcia Herron seconded.
Thank you.
All in favor of the motion to approve the minutes from March 26, 2025, say aye.
Aye.
Any opposed? All right, the minutes are approved. 4B is review and approval of the HRC advocacy rubric, and I will ask Cindy Nguyen to move us through that process.
Hey everyone. So Daisy could not be here tonight, so I'll be speaking on behalf of the ad hoc committee. So we know as a commission, we are often asked to speak on a number of issue areas. So the ad hoc committee developed this rubric so we can have better advocacy efforts, be more consistent and transparent in the things that we do choose to speak out on about. And part of this ongoing transparency effort is outlining the actual process of what we decide to do whenever we do advocate for certain things. So if you can see, I believe the rubric is included in the handouts. There should be a process in there. And if not, we can include that as well. But the first process that Daisy and I discussed, or the first step, was having the issue being brought to the ad hoc committee. So whether that is residents or other concerned constituents, just bringing that up to the HRC in general, and then that would go to the ad hoc committee. Daisy and I discussed who would be a part of the ad hoc committee. So that may include the chair, Eugene Couch, Emma, somebody from communications, and Cindy or Daisy. And then once that issue is brought to the ad hoc committee, the issue is then filtered using the rubric that you see right there. So some of the key issue areas that we would be filtering it out would be things like, what is the alignment with our own mission? Does it have to do with public accommodations, employment, or housing? The second is, what is our capacity as commissioners? Is it something that we are able or have time to speak on? Is it something that we are already working on? The third thing is the urgency and the impact of us speaking out. The fourth key issue area is the amount of residents that are just speaking out in general. How many requests are we getting to speak out on this issue area? And then the fifth is how many other organizations are already working on this? Are there potential partnerships just in case that we can't speak out? Maybe we can work with a partner organization that is already doing the good work, so we don't have to flat out say no. So we hope that this rubric is supposed to be unifying voice for the HRC. We want to be able to respond thoughtfully on all of these matters with a clear criteria, and hopefully that this rubric is going to be an accountability measure for the commissioners and things that we do choose to speak out on.
Thank you, Cindy. Any questions about the rubric or how it might work? I will say, Cindy, I think that the document that we all have does not have that process piece that you described. So we could take that up at the next meeting and make sure that we all have a comfort level with how the process would unfold.
Absolutely.
Okay, and tonight address the rubric itself. Any questions about the purpose of the rubric or how it works, the considerations that are being made?
Dean Couch, I think I just want to understand fully. So the rubric's great. I love the way that it is structured and it's intended to use. To your point, though, about the process not being included, is it what happens from a legal standpoint if we approve the rubric tonight without the process associated with that?
Well, I'm not sure if there's a legal implication.
Okay.
I do think that what's before us is the question whether to approve this as a tool that the commission can use in whatever process is ultimately approved or modified from time to time.
Sure.
And we can also put on the agenda for the next meeting a separate vote on the process that we would follow. I think the process is important, very important, because otherwise the tool is just floating around without, anyone having a pathway for it. So I appreciate the concern. I don't think there's an impediment to us approving the tool, the rubric, and then working on the process in the next meeting. Do you all agree, or does anyone feel that we should pause this and wait till the process is also part of it?
With that, then I'll move for approval.
Okay. Is there a second to approve the rubric?
Great job.
I'll approve.
Brian
Second.
seconds. All in favor of approving the rubric as a tool for the commission to use? Say aye. Any opposed? All right. We've approved the rubric. And I'll just mention these items, as we use them, can be modified and amended. If in practice we find that it should be tinkered with or amended, we can certainly do that. This is not something that we have a template for. Our ad hoc committee was bringing to bear on this work their own personal experiences in organizations, but no one had an advocacy rubric for us to follow. And so this is something that we're learning about, and over time may take some different modifications as we get experience with it. All right, the next item then is 4C, to discuss the communication materials and plans that have been developed by our communication committee. And Brian and Ralph, I'll turn this part of the meeting over to you for discussion.
Well, we've been putting this together for a couple of months now, and we've also discussed it in previous meetings. You all have what's called the communications plan, basically. It's the sheet that starts with the focus for 2025. And I'm just to keep things short and not dig in too much, and then we can discuss the talking points and some of the other characteristics. But ultimately, our objective that we discussed was trying to figure out how we can reach a diverse but targeted audience in a grander scale by doing what we consider kind of a pass-along communication strategy. The focus for 2025 is the housing and public accommodations that we've laid out already. The hurdle that we encounter as a group is we really kind of have a limited amount of resources. We don't really have our own dedicated social media and email platforms and things that we can directly control on a day-to-day basis. So we're really, while the city has a lot of resources there, we're kind of restricted on what we can do and how quickly we can do it and get measurements. So that tends to be a hurdle. So the objective overall of the communications plan was to expand public awareness of the HRC through existing community networks to increase our marketing reach. So basically what we're trying to do there is just create that pass-along rate. The idea behind it is for us to go into the communities, whether it's a neighborhood association or a church organization or any number of organizations that we all operate within, and communicate to them what the HRC is and what the HRC can do, so that if they know someone that they're impacted by, that they now are armed with the information that they can, provide the HRC as a reference. And obviously, it's a delicate issue when we tackle these things. But the intent is to talk to a group of 5 people, 10 people, 20 people, and hopefully they have a network of an additional 100 to 500 people that they're in turn talking with, so that they can communicate the HRC's existence out to their base. And then I think through this strategy, we're going to touch a lot more people than we have in the past, where we were just going into just local what do we call them? Local events where we're setting up a table and handing out brochures. So I think through the strategy, we're going to reach a lot more people. So in target, we've got Oklahoma City residents in general, with an emphasis on populations who need support in housing and public accommodations. Again, the media target are small community organizations who can communicate to a larger following via social media or email database. And then we've got examples of those things, from homeowners association to arts organizations, to outreach organizations, to veteran groups. Just kind of any of these would work, but that's just enough for us as a board to start keeping in mind who do we engage with in our individual bubbles that we can then reach out to and try to book a time or get in front of those people, so that, again, we can educate them on the HRC, but they in turn can forward out our information via social media or email. The message overall that we've been discussing, we initially discussed, you've got some graphics here in your kits, but the initial idea was, do you know someone? Because a lot of the conversations that we've had as a group during our brainstorming sessions is that I may not know somebody, but I know somebody who does know somebody that might have a concern or might need the HRC as a resource. So we may be 2 degrees of separation from it, or we may be 3 degrees of separation, but we're really not that far away from somebody who might be able to lean on the HRC. So the graphic, when we considered that, we didn't want to infer too much by saying, do you know someone? So we modified it over to do you know? And this is kind of a work in progress that you can expand on. But we wanted to make sure that, number one, we wanted a quick calling out point and something a little bit memorable so that somebody's just looking at something in a glance, it'll hopefully help draw them in. So it's not uber creative or anything like that, but we felt like it achieves that goal. We just want to make sure, within our group, that we're not miscommunicating something, that you all aren't interpreting it one way when our intent is to, our intent is a different direction. Do you want to expand on that at all now, or do you want to go through talking points, or?
Well, I guess I would say the talking points is the document that we spent most of our time on. But the plan is important too, and the one item that we paused on and would really welcome discussion about is what is our main message? And we like this approach of do you know or do you know someone. It's very simple, it's very compelling, it grabs your curiosity, your imagination, and your desire to be a good citizen, and to help people. So I think we like it, but we're pausing about it to give everybody an opportunity to speak to its impact. And if it needs to be modified, we can. There are other options. But one thing that the Communications Committee has been grappling with is that we're a new commission. And the fact is that people aren't aware that there is an Oklahoma City Human Rights Commission. And there's a complaint process. There are limited remedies, but we can provide mediation services, conciliation services, and ways to solve a problem, or refer people to agencies or organizations that can directly help them. So we wanted to say, hey, we're here, we exist, and this is what we can do. My pause, I think, and we had a lot of discussion about this, was we don't want to give the impression that we can represent in a legal way a person with a grievance. We can provide some resources, investigate, try to solve the problem by an agreement among the parties, but we are not going to be providing legal remedies or even a legal process in terms of an evidentiary hearing. So we wanted to avoid a suggestion that here's the HRC, we will represent you. We don't have the authority to represent individuals, but we do have the authority and the capacity to help resolve problems in our community. So with that background, I'm wondering if we could stop just for a few minutes and before we go to the talking points, get your reactions to that as a main message, and in particular, a communications piece like this, a graphic, that's what you're seeing first. And it also guides the presenter with a kind of opening for the presentation. Any thoughts about this? And as you're thinking about this, let me just say, we're not contemplating necessarily that we're going to vote on this tonight. We could if someone made a motion, because we put it in the agenda piece where we could vote if necessary. But we really think this is a time for us to consider these pieces and think together about whether they're adequate and effective.
Well, first I want to just thank you two for doing the work, and I know Dean Couch, you probably a big part going, no, wait, because that's what you do best, right? You cause us to really think about ways in which we want to proceed through things. And so I really just want to highlight the media targets and thinking about the list that's been created. These will be people who are probably most impacted by some of the things that happen that cause violations in their human rights. And so if I'm seeing something like this on the website, you know, or in services, or if these are present in, let's say, the Family Justice Center or in different places where people can take them, then I'm all for the opportunity for people to know about us. I try to say it as much and as often as possible, and people are like, what? And I'm like, it's a real thing. It's a great thing that's happening. So thank you guys for putting this together. We've been trying to do it for a while.
We
and so
have.
it's great to see it come to fruition.
And Dr. Herron, you know, we're doing this with the idea that each one of us serving on the commission will find ways to make presentations with groups. This is certainly a non-exhaustive group, a list of groups that we can think about. That plus having a physical flyer or social media piece that we can send out beyond that, or that these organizations can send out. So it's time now for us to be proactive in getting this information out.
I like it. It's a bit of a missing link, and I haven't been on the commission very long, but the website's already built, or is already facilitating inquiries and questions that we can field. It just seems to be getting, now we got to take those tools that we all have in place and connect them with the population. And we're not, you know, we need to reach as many people as we can, because like you said very well, and we discussed the same thing, that it's our churches or different organizations that are really engaging with this need on a day-to-day or a week-to-week basis. And so if we will all take a little initiative to get in front of those organizations that we're already, you know, involved with, it's just sometimes just a matter of making them aware that, hey, this resource is here. So the next time somebody walks in, or the next time you're faced with it, you know, now you have a resource and you can steer them to the right, to the next step. Mm-hmm. So, Ralph, did you have anything on the message or anything that you wanted to communicate?
I kind of wanted to tell you how this came about when we were appointed to our position of this committee. We came through a significant day right after our March meeting in April. And being an retired Oklahoma City firefighter, that day was the 30th anniversary of the Oklahoma City bombing. What birthed out of that is what the Thunder have accomplished. But what came before that, and is still there and resonates across this country, because I've heard it, because when people find out I was with the Oklahoma City Fire Department, first question, were you at the bombing? Every time. So the Oklahoma Standard is what just jumped out of my soul. I portrayed that to Brian, and he took it and put this together, not in the form that you see it, but very close. I'll have to say that we tousled around about not using "do you know?" But that became very evident again to me, and I explained this to you earlier in the week. Last night I had an opportunity to do a very sketchy, impromptu presentation, 3 minutes, period. Didn't want to go any further. And I just stopped and I said, "Do you know?" And everybody in the room looked at me. And that's the catchphrase. And I'll tell you, at first we were going to abandon it, but we came back around to it because it makes sense. Is that, do you know there's a place that can give you some help? Last night I had them all go to OKC. What is it?
.gov/HRC.
Yes, /HRC. And I had it on my notepad, and I told them to get your phone out, go to it. Half of them did. That's a start. That's more people we've contacted in any of the other things we've done. The other thing that I thought was important when Brian talked about this, and the reason I'm trying to give you enthusiasm that if you want to change it, let's do it. But even if you adopt it, Brian and I and the chairman are open to any changes that we think will make it better. Because the last thing we want to do is give us a bad product for the future commissioners. I think this is a good launching pad to tell what HRC is about. Most of you in here know that when we first started this, I was the most conservative guy in the room. And it was obvious that people knew that. I was skeptical, and I used this in my little talk last night. I have been won over by the presentations that we've had over the last year and a half. This is not a right or left issue. This is a Oklahoma standard. We need to do better about taking care of people that are needing some help. And it has taken my soul for us to ask the question, did you know? Do you know? We've got help for somebody. I can tell you, you may know somebody that you see at Walmart that you know that needs help. We can start there. Simple. That's my dog and pony show.
Yeah, I think this brings to mind, too, that we may be asked to speak for 3 minutes or 15 minutes or more. Depending on the group and the time limitations, these talking points can be adapted. And, you know, Ralph has this sort of natural gift for talking to people and bringing people around. I think we all have various levels of comfort with speaking publicly and making presentations. So this tool, the talking points, is really to help all of us have an accurate set of talking points about who we are and what we do and why. And you use that with your own style, with your own personal connections to the HRC and to your groups that you're talking with. And then as we all, you know, are out in the community speaking with organizations, this will become more and more natural for us. So I totally get it that there are some people that are going to be eagerly going out to groups and others who are more reluctant. We can go in pairs, for instance. We could go as a team. And there are all kinds of ways to do it, but we have to begin to do this. And this is designed to help us do that. The talking points themselves, you received them ahead of time. I think we're hoping that you review them carefully so that everybody's comfortable with the tone of it, the information provided. Everything about it should be comfortable for everyone. So Cindy, do you have any thoughts about, I know you're very adept at presentations and being in front of groups. What are your thoughts as we contemplate this?
No, I think this is all great. I think this is something that we've been needing for a very long time, and hopefully this empowers every single one of our commissioners to be able to speak to different groups of folks. So I think this is wonderful.
Yeah, I do too, and I thank Brian and Ralph for all the hard work. I mean, you two are a good team.
We got it knocked out, but I do agree with you. This is kind of a work in progress, and it always will be. So as soon as we hit red flags, or I'm being faced with this in these meetings and things like that, we can always update these talking points. And like you said, they're not necessarily intended to stand there and read, because it would be a long read and a very boring presentation. But it's, you know, it's like, hey, this is the general gist, you know, put it into your own bullet points. How do you want to communicate it? And, you know, some people might be able to give one presentation during the year, and reach by default 500 people, because they're, you know, the people they're talking to have a 500-person base. And that hopefully will get passed along a little bit more as well. So,
and I think having this flyer or something like this, or maybe multiple flyers along this line, is something important, as not only we table at events, so we have to provide this some sort of contact information, but also just to have it meetings, gatherings.
It's important for us when we do this to communicate to our audience, or at least the principal person, that, our intent is for you to take this electronic, documentation that we give to you, or some of this information, and try to pass it along to your constituents or your base, so that they know that, can we count on you, or, in closing our sale, so to speak, can we count on you all to pass this along to your base? And yes, and then great. Well, about how many people is that? Is it 1,000? Is it 15? Is it a small homeowners association or a large church? But once we get that feedback and we know that that's been done, that's been passed along, that's about as far as we can measure it. But I think if we can come back and report back and say, yes, they're sending it out, they're going to send it to 1,000 people, and it becomes part of our trackability, not only the hits to the website, which will hopefully increase, but at least we'll know, kind of how it's getting passed along, and can give some reporting and measurements that way.
Yeah, I think measurements are important here. And if we, for instance, take the next year to put this plan in place and can somehow measure its impact, that will help us moving forward.
Yeah,
so
and
if you
we've
have
already
any suggestions for us.
Well, Emma's done a great job already starting to get web page hits, and where are people, how many people are hitting the website, but then also what pages, and we just really need to kind of start defining that. And I think that's going to be really our primary tracker is, okay, last year we were seeing an average of 200 hits a month, let's say, but suddenly we've spiked up to 500, or whatever that is. That's going to allow us to see whether or not the campaign is doing what we want it to do, and if not, why not?
I think that would be very helpful. We had talked also about presenting in the next meeting a kind of a dramatization of a presentation, and maybe Brian and Ralph, or Ralph and Emma, or some combination of 2 or 3 of us can just do it and have an experience among us all that sort of lets us see how the talking points might work out, how questions might come up, what are the answers to the questions, and so we'll look forward to that. But is everyone in agreement that there's no need to approve these documents, but rather just accept them from the Communications Committee and use them as we go forward?
Chairman,
Yes.
I will volunteer if I can use Brian and Emma as my props to make it look like an impromptu thing, but it'll be giving you ideas. But the thing that I want is you make it personal and you keep attention. And that's what happened last night. Because there were some people that were in the room last night that sat out here and were lobbying for this commission not to be approved and changed their minds because of the way I made it personal. I'm not saying, look at me, but I was trying to get what we're doing across as being the Oklahoma standard, and you can't argue with that.
Yeah, that's a powerful message, and weaving that into our talking points, I think, is really very helpful. All right, anyone have any other questions of Ralph or Brian? Any other comments or thoughts about the communications plans?
I don't know if my speaker's on.
I think it is. No, it's
Back.
not.
Okay.
Yeah.
Sorry. You may want to mention that the plat project is mentioned in the talking points as well. It's not on the focus for the housing and public accommodations, but as we enter into these organizations and these groups, there's going to be times when that's important information for them to know, whether it's an HOA or something like that. So.
Right, that's a bullet point in these talking points. Obviously, that is a time-limited project. It'll probably take a couple of years to complete, so we may be asked about it often if we are doing these presentations. Emma is going to give a presentation about where we are on that plan right now. And it's a rather complex thing, but I will say that I talked to my own neighborhood board about it and got some surprising responses. So when we have time, I want to be sure after Emma's presentation today, I think it'll be clear how this is going to unfold, but we might want to talk in the next meeting about that, how to explain this plat amendment project. But Emma's going to help us a lot right now. So if everybody's ready to go on to the next item, we will. Okay, Emma?
Hello, everybody. I'm going to keep this quick because we are running late. So if you want to, you can look at it up here. You can also press the presentation button on your little keypad if you want to see it right in front of you, and hopefully that'll work. So basically, I gave this presentation in front of City Council when we wanted them to sort of mirror the resolution that we passed, just in favor of this process. And then I also recently presented to Planning Commission. You'll see that they're involved in this process. And then a bit of foreshadowing. Jonathan will be presenting in front of the Historic Preservation Commission in like a couple weeks, which will be great because they're also a part of this. So thank you, Jonathan. Okay, so I don't think this is news to us, but just as a reminder, in the early to mid 20th century, racially restrictive covenants were widely used across the United States, which also includes Oklahoma and Oklahoma City. These covenants were legally enforceable until 1948, until Shelley versus Kramer. However, even though these covenants are not legally enforceable, many of them still exist in plat documents today. And so last year, Governor Stitt signed a bill into law which allows municipalities to amend plat documents to, we won't say remove, to address this discriminatory language. And so previously it was the burden of the property owner to sort of file for an amendment, but this law allows municipalities to do this. And so it's great in kind of expediting this process. The only jurisdiction in Oklahoma who's actually gone through this process is Edmond. And so we've been in communication with them and their planning department just to sort of talk about what this process is like and get some pointers. They've been incredibly helpful. So we're really grateful to them in that partnership. So as you all know, in March, we passed a resolution in support of this process led by the city, and then council followed that soon after with their own resolution. So basically where we're at, this is the process as we think it's going. Obviously different things have been added and I assume we'll run into more hiccups. So there are around 6,000 plats in Oklahoma City. That's a lot of plats. We have a big city. However, not all of them were sort of created before 68, which is where we think that after the Fair Housing Act, it would be especially egregious for any of them to contain this discriminatory language. So we're really trying to focus in on a rough estimate of 2,200 that were created before 1968. But really, if it's 200 plats, if it's 2,000 plats, that has large implications for the operational exercise of amending these plats. And so we need to basically comb through them and identify which ones contain discriminatory language, which they're all publicly available on the county website. It is an incredibly manual process. They're PDFs, they're scans of old documents. You have to kind of squint your eyes and like read the cursive and see. So I'll get to that in a second. But basically, what we're doing now is we're trying to take 3 plats through this process to iron out kinks, see who all we need to talk to, and then hopefully use that to get a process in place, understand the budgetary impacts, and make sure that we have engaged all of the relevant stakeholders. So say we have a plat and it's in a historic district or preservation area, we would have to take that plat to HP Commission. They would have to give a recommendation. Then it goes to Planning Commission. And before it is actually heard by the Planning Commission, a notification has to be sent to each property owner in the affected plat telling them, hey, this is coming up on the docket. This is the language contained in the plat that you live in. Here is what the amendment we are proposing. You're welcome to come speak at the next Planning Commission meeting. That has to be created. Those maps obviously differ based on plat. So those have to be like created and mailed to all property owners 30 days before a Planning Commission meeting. Planning Commission would then make another recommendation for amendment. Then city council has to approve it. Then we would file an amendment with the county. So you're seeing the bureaucracy in front of you. So that is where we are at right now. Again, Jonathan's going to present in a couple weeks to historic preservation. Obviously, not all of them will be in historic neighborhoods, but we just want to say, like, what is the starting point here? Once we do those three and get a more detailed process in place, then we'll be thinking about some kind of volunteer event, hopefully to literally just have people like go on the county website, start combing through these 6,000 plats and identifying which ones need to be amended. And that's basically it. Any questions?
Did you touch on the map plotting process?
Yeah, so
I thought it was a great idea. I think it would be helpful.
yeah, so I guess another update that we just got some news about today is OU, the Institute for Quality Communities, offers these learning experiences for their graduate students to help be involved in projects that benefit the community. And so Marcia connected us to Dr. Wiley, who just started leading this program. And so we applied to have an OU student or students and potentially faculty partners join us in this plat process. And so we're actually going to hopefully meet with them next Monday or Tuesday to firm up the specific sort of scope of their work, because depending on what the student wants, I think we have a multitude of needs that they could be helpful for. One of it is mapping, because I think, again, in their current existence, these plats exist in PDF form, or the city on our open data portal does have a map of all the plats, but I think visually, to help understand that this impacts across the entire city, all wards, and just sort of track progress on us amending these, and to tell a story about the history and not shy away from it, and also highlight the efforts that we're making that hopefully community partners are joining us in making as well. I think that would be great. So we want to think about communication. If we go out to different advocacy groups or HOAs, we want them to feel like they can partner with us and work with us. This isn't just a city thing or an HRC thing. This should be a citywide or broader city community effort. And so we want to be a resource, but I think sort of having some kind of visual or communication about the process in the overall project would be great and really helpful for folks. What else?
This would be, in looking at the organizations that were identified for churches to get involved, because this is not just a human rights issue, but it's like a people humanity kind of thing. And so if you have people living in neighborhoods where maybe they're not aware, but it is discriminatory, having our churches become involved and supply volunteers for this would be a very good opportunity for us to connect.
Yeah, I mean, I think the volunteer event, it's not fun work. We need people power to literally review documents. And so I think, again, it's another great way to raise awareness. I think oftentimes if we go out and we're talking about the HRC, we're just saying it's a resource available, but this is a way to invite people in to say, if you care about human rights, you want to see our city be inclusive of all neighbors, maybe you don't know someone specifically right now, keep that in the back pocket, but here's a way that you yourself can come volunteer and engage with us. So yeah, I think it's great for probably any of those groups that Ralph and Brian had listed.
Questions about how this will work? Anyone?
It's evolving too, so we'll keep you posted per usual, but that's the current state.
It is evolving, and one of the things I'm learning, I think, is to clarify that this new law doesn't allow you to go into the plat and X out the discriminatory language or excise it. It allows you to amend the plat. So physically, as I'm looking at it, some sort of document will be filed with the plat that declares that provision null and void, gone. Right now, the plat, if you look at it physically, it doesn't have any indication that that's illegal. And that's what I've had to wrap my mind around is physically, what are we doing? We're not really removing the language. And that one of the concerns that was raised when I made this presentation was, well, isn't this like erasing history? This is a historic document. You're erasing history. Well, we're not erasing history at all. It will still be there as a historic, has historic evidence. Okay, well, more to come on this, and as we do our outreach through the communications plan, this is going to come up, and we want to have accurate information for us to use. Emma, do you have any more information for your compliance officer's report?
Yes, just a couple quick things. So since the March meeting, there have been 15 complaints. 8 out of those 14 have been referred to other agencies. And then 3 of the 14 were outside of our jurisdiction, but only because they had already filed with another agency. So in fact, I'm thrilled that they were able to sort of find the right place even faster than needing us to refer them. So again, as per usual, not a huge volume of complaints, and hopefully they will be directed to agencies who can help them with what they need. And then the other thing is, and maybe Cindy, I don't know if you want to pop in on this, but Adam will be hosting a Tenant Know Your Rights event on August 5th at the Downtown Library. And Councilperson Hammond just reached out and invited the HRC to see if we wanted to sort of table. They're going to have other organizations there, including some of our partners who we've hosted at our own meetings. So obviously, we all saw Adam's presentation. It was super informative. So I'm out of the country, but I promised her that I would ask here, and we can talk offline as well, August 5th, if anyone is able to set up and table. I think setup is from 5 to 6 p.m. The event starts at 6 and will probably go until like 7:30. So 5:30 to 8-ish at the Downtown Library. If there's someone that could table or a couple people, we can either print more of these communication materials. I have some brochures that I made for a different pop-up event that are in English and in Spanish if we want another option that way. We can get you all set up with like that poster thing if we want for people. So I'm happy to help coordinate
banners,
that. Yes, the
yeah.
banners. Happy to help coordinate if that's useful. We can print out some complaint forms in case people want paper versions. So I don't know if anyone right away knows. If not, if you could sort of make note and let me know. I just want to get back to her ASAP since the 5th is coming up. But that's all I have.
All right. The chair's report is going to be short as well. I first want to return to Stephanie Holloway, who we welcome here as a new commissioner. And Emma and I have met with her, and it's going to be wonderful to have you with us. Stephanie has spent many years in commercial real estate development and management, an area that, I mean, you talk about needing skills in collaboration. I think that's one place that you would really learn that, and that is very resonating with our work here. We're building partnerships and working with other organizations to be effective. So that is one aspect of your past that I think is going to really dovetail beautifully with what we're doing. Stephanie has worked with the American Red Cross for many years and been involved in other community initiatives and organizations. And I just wanted to give you a moment, Stephanie, to say hello and tell us a little bit about yourself and why you wanted to serve on the Human Rights Commission.
I guess, do I need this one or am I speaking?
I believe the mic is on now.
Yeah.
Well, I'm thankful to be here with each one of you. You know, I have a passion for serving others and, you know, making sure that everyone's voice is heard. And so when I heard about this committee, the, you know, commission, I was like, well, yes, it fits everything that I believe in. So I'm appreciative. I'm married. My husband is here with me this evening.
Chuck Holloway, would you stand and be
Chuck
recognized?
Holloway. We have 3 children who, are growing and vibrant within the community, and I want them to learn how to serve and be a part of our communities as well. So that's a little about me. And 2 fur babies, can't forget those.
Fur babies, of course.
Yes. So I'm just thankful to be here and to help within the community.
Well, we're eager to get you involved in our committees and get you involved in some of the projects we're working on.
Thank you.
Thank you so much. Quickly, I will remind you that we have a number of commissioners whose initial terms are expiring. These are wards 1, 3, and 7, and the chair. So we have work to do to make sure that reappointments are processed well as well as if there's not going to be a reappointment, that successors are going to be thoughtfully put forward. We do have an application process. The city has an application process for anyone who wants to serve on a city commission, and so we are monitoring those that mention the HRC and are wanting to make that system work well so that the process of coming on board with us is open and not just like who we might know, or we really want to be a place where the city's residents feel that they can serve as well. So keep that in mind, and please keep me informed about your plans, those of you in wards that are affected. Also, the vice chair of this commission serves a 1-year term, and so I'm going to ask our Rules and Governance Committee to be the nominating committee for the next vice chair. I am not seeking reappointment as the chair, as I think all of you know by now. My husband and I are moving to Norman, and regrettably, if you're not a resident of Oklahoma City, you can't serve on the commission. So then that position is an at-large position. The mayor appoints that position. So you all be thinking about whether you would like to be chair, and or if you know others who would love to serve in that position. So I also want to report to you that we've heard from Legal Aid Services of Oklahoma about the loss of very significant loss of federal funding for their tenant representation program. And I don't know the extent of it now, but it looks quite devastating. And in terms of having some organization to refer people to for legal representation in evictions, it's going to be a lot more difficult. We do have OCU Law's clinic, and they're wonderful. There are a few other organizations, but we may receive many more contacts and complaints because of the loss of the legal aid program. So I'll try to learn more about that by our next meeting. All right, remarks and announcements. At this point, we will have members of the public come forward and address the commission, and I'll start with MQX. Is there a person named MQX? No? It's Max. Oh, okay. Max, okay. Audra Beasley, Max. Okay. Yeah, you have about 3 minutes, Ms. Beasley.
Emma, I have an email from you from back in January of 2024 addressing the lack of restroom access in this building. And Councilwoman Barbara Peck, we recently had unanimous support from the City Council on new building standards. I filed multiple ADA grievances with the city regarding this building, the Paycom, Myriad Gardens, our state fair. And tonight, as we gather here for this Human Rights Commission meeting, he still does not have temporary accommodations in this building. And I have brought it to this commission several times. You now represent us in Ward 5. And is it going to take you and Matt Hinkle and the ADA coordinator and Max and I coming around and talking about Title II of the ADA and the city's requirements when processing an ADA grievance? I've filed a complaint with the United States Department of Justice against the City of Oklahoma City. And I believe every single one of you on this commission should be taking me seriously tonight. Where does Max have restroom access in this building tonight? Can any of you answer that question? Someone needs to stand forward and say, there is a empty office somewhere where I can provide you a safe and private space for me to help him with his toileting needs. Right now, the City of Oklahoma City, this building is not in compliance with the ADA. Because I've brought a very well-known barrier to many people for 6 years. And tonight, as I stand here, there still is not temporary accommodations in this building. Mayor Holt knows it. Every member of our city council knows it. And why it's being ignored is a detriment to our city. And I should not have to sue the state and the city. Wilkinson and Joy Turner, those two helped Max get temporary accommodations at the state capitol and helped us fight Greg Treat for 2.5 years to get that adult-sized changing table put in at the capitol. And they sat there and acted like they did not know us tonight. They're named in charges with the AG and a complaint with the United States Department of Justice. What is it going to take to get temporary accommodations in this building? Our brand new ADA coordinator told me just yesterday that the OG&E Coliseum has an adult-sized changing table, and if we were to visit any of the events out at the state fairgrounds, that building is what provides him restroom access. We could not be having our city employees on a public payroll telling me to leave a public building to go to another public building for his accommodations. Is the OG&E Coliseum going to open its doors to you to go to the restroom whenever you're visiting any of those buildings out there for any of those major events? I need someone, whenever I email the HRC, I need a name attached to it. I agree with you. Each and every single one of you needs your own email address. It is ridiculous that whenever I email the HRC, I'm responded to and have no clue who I'm talking to. In the last communication I had, someone refused to tell me who I was talking to, and that is not acceptable. I'm asking each one of you to contact the city and act. I should not have to sue the city over this. I have a Walmart list. Do you think Max has access at Walmart? Because he does not have restroom access in this building, I will be forced to go home. We will go to the restroom, and then he stays at home while I go to Walmart. I should be able to help my son with his toileting needs in this building before I leave. We've been here 2 hours. It is not an issue that can be ignored any longer, and I might just become your biggest pain in the butt. It has been 6 years, and I want to see action tomorrow. I want someone to call me up on the phone. You have my number, and you tell me where Max has temporary accommodations in this building. Where he does at the state fairgrounds. Why did it take 6 years to order a $2,600 table for the Paycom Center, and why did the Thunder allow that? When John Rex opened, all are invited to that charter school. And the amount of barriers, attitudinal barriers, that are brought to me and my family in the city, the amount of harassment that we have endured over just saying, my son is a disabled American and requires a changing table that exceeds the 50-pound weight limit that this building provides. None of you would want to be directed to the floor in a restroom. None of you would want to say, well, the Metropolitan Library has a changing table, or the Civic Center Music Hall, go over there. That is discrimination. And we cannot be having our ADA coordinator direct me that when I'm on the fairgrounds that I have to go to the OG&E Coliseum for him to have restroom access.
Ms. Beasley, your Your 3 minutes have expired.
How many times am I going to have to bring this issue to the HRC?
Well, let me,
I believe it's the last time.
Let me clarify for you that the appropriate person in this area is Scott Hogston, the ADA coordinator for the city.
He doesn't know his job, ma'am. And I'm frustrated.
Well, the HRC has no authority over this area.
Do you have, what is your, if you're
interested in
human
gathered,
rights, if you are gathered, the basic human needs.
Excuse me.
I think you've been part of the problem this whole time. Because for 2 years now, I've been asking this HRC for help, and it has fallen on deaf ears. I have an email from you from 18 months ago.
Ms. Beasley, your time has expired.
Would you like to ask them? There's going to be another complaint filed with the United States Department of Justice tonight because there's not temporary accommodations in this building for him. And every single one of you will be named.
So, just to clarify, the HRC has limited authority to address complaints, and one area that's carved away from our authority is anything that has to do with the city. So the city has already established a grievance process that people can use to address issues like this. We can't have double processes going on and competing results. So the appropriate avenue for a complaint of this nature is through the city's own grievance process through the ADA coordinator. And I'm hoping that those processes will yield some good results. We have had Ms. Beasley speak before, one time as I recall, to the HRC. And we appreciate her speaking to us and informing us about this. All right, any members of the commission have any announcements or last thoughts for the night? Dr. Herron?
I don't know if it's the last thought because I'll still be here in September, but I am not seeking reappointment to the commission. So I'll give my farewell in September, but I just wanted to let you all know so that it wasn't a shock on the last meeting that I would be leaving the commission.
Thank you, Dr. Herron. We hate that. We definitely hate that, but we certainly understand.
It's because they keep nominating me as vice chair.
If we promise not to nominate you as vice chair, we just stay.
Well, you do such a good job, it's hard to not do that. You've certainly been pivotal in the creation of this commission, so we thank you for your service. I will not be at the September meeting myself. I will be out of town, and so I will take this opportunity to appreciate you now. Thank you so much for all your efforts and for your commitment to our community.
It has been a pleasure serving with you, Barbara. I really appreciate everything that you brought to the commission.
Thank you for saying that.
Any other confessions, admissions? All right, and members of the city staff, any comments, directions, instructions?
Keep up the good work.
All right, thank you so much.
I agree with Rita.
And Jonathan, thank you for making a presentation for us at the Planning Commission. At the Historic Preservation District. Thank you. All right, we are adjourned. Thank you, everyone.
Does anyone have